After my daughter Emily's funeral in Seattle, my son-in-law, Mark Henderson, pulled me aside in the crematorium parking lot and said flatly, "You have 30 days to move out. I need a fresh start." The air still smelled faintly of smoke and wet stone. A thin drizzle coated the asphalt, turning the world into a muted reflection of itself. People were still hugging each other near the entrance, speaking in soft, reverent tones about courage and faith and how she's in a better place now. Mark didn't lower his voice. 30 days. No hesitation. No courtesy phrasing. No gratitude for the 6 months I had lived in their house, cooking, cleaning, driving, managing paperwork, paying bills when he forgot. He didn't look like a man grieving a wife. He looked like a man finalizing logistics. I studied him carefully in that moment. I have spent my entire professional life reading people across boardroom tables, in negotiations, in compliance hearings. Grief has a posture. Shock has a rhythm. Mark displayed neither. His jaw was tight, but not from sorrow. From impatience. "I understand," I said. I did not argue. He expected resistance. I saw it in the way his shoulders subtly tensed before I answered. When I simply nodded, the tension dissolved. Relief replaced it. That detail lodged itself in my mind. Relief. That night, after the last guest left and the house fell into a strained quiet, I packed. I moved deliberately, without visible urgency. Clothes folded into 2 suitcases. Shoes wrapped in paper. A framed photo of Emily at age 10, missing her front teeth, smiling into summer sunlight, placed between sweaters so the glass wouldn't crack. But I was not packing to leave. I was extracting. I removed 3 file folders from the office cabinet: insurance policies, banking statements, and estate documents. I copied the contents of the top drawer into my briefcase. I unplugged 2 external hard drives from the back of the desktop computer. I took Emily's laptop from her nightstand drawer, the one Mark believed she no longer used. He watched me once from the hallway. "Just taking memories?" he asked. "Yes," I replied. He nodded. He never asked what was in the folders. By midnight I was on Interstate 5, driving south toward Portland. I kept the radio off. The only sound was the hum of tires and the low vibration of an engine that had seen too many winters. Grief can distort judgment. I do not allow it to. 3 months before the funeral, I had begun noticing irregularities. At first, they were minor. Administrative. Easy to dismiss. An unfamiliar insurance envelope in the mail stack. I had been managing Emily's paperwork during her treatments because chemotherapy left her fatigued and mentally foggy. I opened everything by default. The policy was new. Issued 8 months earlier. Coverage amount, $2. $3 million. Primary beneficiary, Mark Henderson. I asked Emily about it while she rested on the sofa. She frowned slightly. "Mark said it was just updating our financial plan," she said. "In case things get worse." Things had already been worse. But I said nothing more. 2 weeks later, I discovered a revised will draft printed from the home office computer. The language had changed in 2 significant areas: guardianship of my granddaughter and executor designation. Originally, I had been named both. The revision listed Mark's younger sister as guardian and co-executor. Emily had not discussed this with me. When I asked her quietly, she looked genuinely confused. "I thought we were just reorganizing formatting," she said. Formatting. That word echoed. Mark dismissed my concern. "You're reading too much into things, Richard. It's standard estate cleanup." He smiled as he said it. The smile did not reach his eyes. Then came the medication issue. Emily had been prescribed anticoagulants as part of her treatment protocol. I had been picking them up from the same pharmacy for months. I knew the packaging, the labeling, even the texture of the blister packs. One evening, the capsules looked different. Color slightly darker. Manufacturer label different. When I asked, Mark said the supplier had changed. "You're being too emotional," he added. "Stress does that to people." I catalogued the statement without responding. 2 weeks before her final hospitalization, Emily called me into her bedroom after Mark had gone downstairs to take a call. Her voice was thin, breath shallow. "Dad," she whispered, "if anything happens, check my computer." Her eyes held mine steadily. "Check everything." I told her not to talk like that. But I memorized the sentence. The following morning, while Mark showered, I backed up the entire contents of her laptop onto an external drive. He had been using it late at night. I had seen him once, closing it abruptly when I entered the room. "Paying bills," he had said. He did not look like a man paying bills. He looked like a man editing something. Emily's decline accelerated shortly after. Internal bleeding. Unexpected complications. The doctors spoke carefully, clinically. I listened without interruption. I asked precise questions about dosage, interactions, timing. Mark cried convincingly in hospital corridors. He placed his hand on my shoulder twice in performative solidarity. When the machines went silent, he held my granddaughter and said, "We'll get through this." He did not look at me when he said it. Now, in Portland, seated at a small kitchen table before dawn, I placed Emily's laptop in front of me. I did not open it immediately. Instead, I constructed a timeline in my notebook. Insurance policy initiated 8 months prior. Will revision 3 months prior. Medication variation 6 weeks prior. Significant transfers from Emily's personal account 2 months prior. Rapid deterioration following medication change. Patterns. Not conclusions. Patterns. At 6:17 a.m., I powered on the laptop. The start-up screen illuminated the room. I entered the password she had used since college. It worked. The desktop appeared. There, in the lower right corner, was a folder labeled "If something happens." My pulse remained steady. I opened it. Inside were scanned copies of correspondence between Emily and her attorney. Emails referencing pressure. A note stating, "Signature doesn't look like mine." A draft message unsent, describing fear of being managed. There was also a document labeled, "Insurance Concern." I leaned back in the chair and closed my eyes for exactly 5 seconds. 30 days, he had said. He thought removal meant safety. He thought grief meant blindness. He thought age meant weakness. He underestimated experience. He underestimated documentation. And most of all, he underestimated silence. Silence is not surrender. It is preparation. The folder labeled, "If something happens," was not dramatic. No emotional letters. No accusations. Emily was never theatrical. She was precise. Inside were 14 documents. The first was a PDF copy of the life insurance policy Mark had described as standard financial planning. The coverage had been increased twice within 6 months. The second increase occurred 3 weeks after her oncologist described her prognosis as manageable with treatment. Manageable. The second file was a chain of emails between Emily and her attorney. The subject line read, "Guardianship Clarification." In the messages, she asked why her draft will listed Mark's sister as primary guardian of her daughter. The attorney replied that the change request had come directly from her household and included a signed authorization form. Emily's response was short. "That signature does not look like mine." The email chain ended there. There was no follow-up. The third file was more concerning. A spreadsheet exported from her personal bank account. I recognized the format immediately. It listed transfers totaling $187,000 over a 9-week period. The recipient was an investment firm in Bellevue. I searched the firm's name online. The managing partner listed on the website, Mark Henderson, junior partner designation. He had never mentioned an investment role. I leaned back and reviewed the timeline again. Insurance increase. Will alteration. Large transfers. Medication irregularities. Patterns. The fourth file stopped my breathing for a moment. It was a saved browser history export. Emily had searched, repeatedly. Symptoms of slow internal bleeding. Can anticoagulants cause fatal hemorrhage? How to detect medication tampering. The timestamps were within 10 days of her final hospitalization. I stared at the screen. She had suspected. That knowledge altered the emotional structure of everything. At 7:42 a.m., I began copying the contents of the folder to 2 separate encrypted drives. Redundancy prevents loss. Loss prevents justice. By mid-morning, I had printed every document and organized them chronologically in a binder. I did not allow myself to jump to conclusions. I did what I have always done, build a case on verifiable data. At 11:15 a.m., I contacted a private laboratory in Oregon that specializes in independent pharmaceutical analysis. I asked about testing residual medication samples for composition discrepancies. They required physical samples. I had taken 3 unopened blister packs from the kitchen cabinet before leaving Seattle. I drove to the lab that afternoon. The technician did not ask questions. I paid for expedited analysis. 48 hours. That evening, I reviewed the external hard drive I had backed up weeks earlier. I searched for metadata changes in Emily's will document. The file properties showed edits made from a device labeled MHOffice at 1:13 a.m., the night before she was admitted to the hospital. Emily had been sedated that evening. At 9:04 p.m., I drafted an email to 2 homicide detectives in Seattle whom I had met years ago during a corporate fraud case that escalated into criminal prosecution. I did not accuse. I requested a confidential meeting regarding potential irregularities surrounding a recent death. I attached no documents. Information should be delivered in person. At 6:32 a.m., 2 days later, the lab called. The voice on the other end was careful. There are trace compounds in these samples that do not match the manufacturer's listed formulation, the technician said. Specifically, there is an elevated presence of a secondary anticoagulant compound not prescribed in the patient's file. Could that compound accelerate internal bleeding? I asked. Yes. I wrote nothing down during the call. I simply listened. At 10 a.m., I met detectives Daniel Reeves and Carla Martin at a neutral office in downtown Portland. I handed them the binder. I described the timeline without embellishment. I provided the lab's preliminary findings and the metadata discrepancies. They asked precise questions. I answered precisely. Why didn't you confront your son-in-law? Detective Reeves asked. Because confrontation alerts, I replied. Documentation convicts. They nodded. Seattle jurisdiction would require local coordination. That would take time. But once formal inquiry begins, financial records can be subpoenaed, devices seized, and toxicology expanded. 48 hours after I left Seattle, Mark received a visit. I was not present, but Detective Martin later described it clinically. They knocked at 8:17 a.m. He answered wearing gym clothes. They asked him to accompany them downtown for questions regarding recent financial activity and insurance modifications. He asked if he needed an attorney. They said that would be wise. While he was at the station, a search warrant was executed at the house. Computers were seized. Prescription bottles were catalogued. Bank statements were collected. I remained in Portland. Distance prevents emotional interference. Within 3 days, digital forensics confirmed that Emily's electronic signature on the will revision had been generated using a copied signature file extracted from a scanned document and pasted into the template. Forgery. Financial investigators traced the $187,000 transfers. The funds had been moved from Emily's personal account into a short-term private equity account in Mark's name. The investment vehicle had attempted to accelerate liquidity based on projected insurance payout timelines. Projected. That word alone suggested anticipation. When confronted, Mark initially denied wrongdoing. He claimed Emily had approved everything. He described her as confused near the end. He implied cognitive decline. Digital timestamps contradicted him. The lab's full toxicology report confirmed chronic exposure to a compound capable of compounding anticoagulant effect beyond prescribed dosage. Not accidental contamination. Systemic presence. On the 5th day, he altered his story. He suggested dosage miscommunication. Pharmacy error. Stress-related oversight. There are only so many revisions of a lie before structure collapses. 1 week after the funeral, Mark Henderson was formally charged with second-degree murder, financial fraud, and document forgery. He thought removing me would end scrutiny. He thought I would grieve quietly and disappear. He did not anticipate that silence can be investigative. He did not anticipate that experience sharpens under pressure. And he did not anticipate that a man who has already buried his wife does not fear legal war. When I received confirmation of the charges, I did not celebrate. I simply closed the binder. This was no longer suspicion. It was a case. The day Mark Henderson was formally charged, I did not feel triumph. I felt alignment. Events were finally moving in the direction of documented truth. But charges are not convictions. And arrests do not automatically secure outcomes. I have seen too many cases collapse under procedural errors, emotional witnesses, or poorly preserved evidence. So I began preparing for the long phase, the part most people underestimate. The part after the headline. First, I secured redundancy. Every document I had gathered, insurance policies, metadata analysis, toxicology results, email correspondence, financial transfers, was scanned, encrypted, and stored in 3 separate locations, 1 physical safe deposit box in Portland, 1 with my attorney in Seattle, and 1 digital archive under controlled access. Experience teaches you that evidence can disappear. I do not allow disappearance. Second, I retained independent counsel. Not a family lawyer. Not an estate attorney. A criminal litigation specialist with experience in financial homicide cases. Her name was Elaine Porter. Calm. Surgical. Efficient. Our first meeting lasted 2 hours. She did not waste words. Your son-in-law's defense will attempt 3 angles, she said. Medical inevitability, cognitive decline, and shared financial decision-making. They will portray you as a grieving father constructing narrative from coincidence. I nodded. I expected that. She reviewed my binder and paused at the medication discrepancy timeline. You documented before the death, she said. That matters. It eliminates retrospective bias. Yes. That was intentional. Third, I began reconstructing Emily's final 6 months in granular detail. Not emotionally. Chronologically. Every appointment. Every prescription refill. Every insurance modification. Every account login. I subpoenaed, through Elaine, the pharmacy's internal inventory tracking. Batch numbers, distribution logs, substitution authorizations. There was no official supplier change. Which meant the altered medication did not originate from the pharmacy. That narrowed pathways. Financial forensic specialists, engaged by the prosecution, traced not only the $187,000 transfer but also an attempted early payout inquiry on the life insurance policy made by Mark's email address 2 days after Emily's second hospitalization. 2 days. He had requested clarification on expedited beneficiary disbursement in the event of terminal outcome. Terminal outcome. Language reveals mindset. Meanwhile, Mark's defense team began quiet outreach through intermediaries. One message reached me through a mutual acquaintance: perhaps a family resolution is possible. Family resolution. I did not respond. There are moments when silence must be unbreakable. My granddaughter became central to my strategic planning. Custody proceedings would be inevitable. With Mark charged, emergency guardianship review was triggered automatically. Because the will revision was under criminal scrutiny, the original guardianship designation regained presumptive validity. That designation named me. I did not celebrate that either. I prepared. I underwent a voluntary psychological evaluation to preempt any defense suggestion that I was emotionally unstable or acting out of grief-induced paranoia. The evaluator's report was clear: cognitively intact, emotionally regulated, no pathological grief response. Documentation again. I submitted to background verification, financial stability review, and residential inspection in Oregon and Arizona, where I was considering relocation. Proactive positioning prevents reactive vulnerability. While legal machinery moved forward, I continued analyzing digital artifacts seized from Mark's devices, summaries of which were shared with the prosecution and, through discovery, with defense. There were deleted search queries recovered from his laptop. Undetectable anticoagulant interactions. Time to fatal hemorrhage in oncology patients. Insurance payout timeline. Homicide suspicion. Search engines do not forget as easily as people hope. The most chilling artifact was a draft email saved but never sent. Addressed to an unknown contact, it read: "Once policy clears, we're clear." Ambiguous in isolation. Devastating in context. As months passed, Mark's demeanor shifted from denial to negotiation posture. His counsel explored plea frameworks. Second-degree murder carries heavy sentencing exposure. Combined with financial fraud and forgery, the cumulative penalty was significant. But my focus was not punishment. It was protection. Protection of Emily's memory. Protection of my granddaughter's future. Protection of documented truth. Before preliminary hearings, I reviewed every photograph taken from the lake house months earlier: the life insurance policy on the counter, the altered will draft, the medication packaging variation. Each image time-stamped. Defense attempted to imply that medication anomalies were contamination from storage. Laboratory chain of custody records dismantled that suggestion. Defense implied Emily had depressive ideation that could explain browser searches. Her oncologist testified she had shown no suicidal markers, and that her prognosis, while serious, was not immediately terminal at the time of policy increase. The financial motive tightened around Mark like wire. In preparation for public proceedings, I anticipated reputational counterattack. It is common in such cases for defense to portray the reporting family member as financially motivated. So I preemptively transferred any claim I had to Emily's estate into a trust designated exclusively for my granddaughter's education and long-term care. Irrevocable. Transparent. Filed publicly. There would be no argument that I benefited financially from Mark's prosecution. The day before arraignment, Mark's attorney requested a private conversation with Elaine. The proposal was simple: a reduced charge plea in exchange for full financial restitution and admission of falsified documents, but not explicit admission of intentional poisoning. Elaine relayed it to me without commentary. "Your position?" she asked. "My position is that truth is indivisible," I replied. "Partial truth is another form of concealment." I declined. Preparation continued. Forensic accountants uncovered an additional layer: Mark had quietly adjusted Emily's online banking notification settings 6 months prior, rerouting transaction alerts exclusively to his email. Isolation. Control. Incremental manipulation. It was never impulsive. It was structured. I assembled a master timeline, 72 pages long, integrating medical, financial, digital, and legal events. Every date cross-referenced. Every anomaly contextualized. Every pattern visible. I did not rage. I did not confront publicly. I built. Because exposure without foundation collapses. But exposure built on documentation is irreversible. The trial date was set. And by then, the structure was immovable. The courtroom was colder than I expected. Not physically. Structurally. Fluorescent lighting. Neutral walls. No dramatic architecture. No cinematic tension. Just procedure. That is how irreversible things happen, quietly. Mark Henderson sat at the defense table in a navy suit I recognized. I had seen him wear it to Emily's oncology fundraiser the year before. He kept his hands folded, posture controlled, jaw set in what he likely believed projected composure. He did not look at me. That was deliberate. The prosecution opened without theatrics. No emotional appeals. No raised voices. Just sequence. Insurance policy initiated 8 months prior. Coverage increase aligned with worsening diagnosis. Will alteration submitted with forged authorization. Bank transfers totaling $187,000 redirected into defendant-controlled investment account. Medication samples containing unprescribed anticoagulant compound. Digital search queries related to hemorrhagic lethality and insurance payout timelines. Patterns presented without commentary are more powerful than accusations. The toxicology expert testified first. Clinical. Exact. She explained how the additional compound amplified the prescribed anticoagulant's effect beyond therapeutic range. Chronic exposure. Accumulation. Progressive internal bleeding. Not immediate. Gradual. Strategic. The jury did not react outwardly. But I saw the shift in posture. The stillness. The forensic digital analyst followed. He described metadata signatures, timestamp mismatches, and signature file duplication in the altered will document. He displayed the original scanned signature and the copied overlay. Pixel for pixel alignment. Forgery does not survive magnification. Then came the financial analyst. Calm voice. Charts projected on screen. Transfers from Emily's account to the Bellevue investment firm. Defendant listed as managing partner. Attempted liquidity acceleration inquiry submitted 2 days after hospitalization. Once policy clears, we're clear, the analyst read from the recovered draft email. Silence settled across the room. Defense attempted to suggest stress-induced error. Cognitive confusion. Shared marital financial decisions. The prosecution did not argue. They displayed. They showed Emily's browser history. Symptoms of slow internal bleeding. Detecting medication tampering. The timestamps preceded her final admission by 9 days. The oncologist testified next. Was the patient terminal at the time of insurance increase? The prosecutor asked. No, he replied. Her prognosis, while serious, was responsive to treatment. She was not expected to decline at that pace. Defense suggested pharmaceutical supply variation. The pharmacy director refuted it with batch tracking logs. Chain of custody. Inventory continuity. No supplier change. No contamination report. Then came the moment I had prepared for. My testimony. I took the stand without visible emotion. I described the parking lot conversation. The 30 days. The relief in his posture. The document folder. The medication variation. Defense counsel attempted to paint me as suspicious, controlling, financially interested. I had anticipated it. I presented the irrevocable trust documents transferring all estate benefit to my granddaughter's long-term educational fund. No personal financial gain, the prosecutor clarified. Correct, I said. Why did you not confront the defendant immediately, the defense asked. Because confrontation alerts, I replied. Documentation convicts. The courtroom remained silent. I did not raise my voice. I did not accuse. I described sequence. I described patterns. I described restraint. The prosecution rested. Defense called only 2 witnesses, a character reference and a pharmacology consultant attempting to introduce ambiguity regarding compound interactions. Cross-examination dismantled both. The pharmacology consultant admitted the secondary compound could not have originated through normal therapeutic substitution without documentation. There was none. After 3 weeks, closing arguments were delivered. The prosecution's final statement was simple. This case is not about grief. It is about design. The jury deliberated for 9 hours. When they returned, the room felt smaller. Second-degree murder, guilty. Financial fraud, guilty. Document forgery, guilty. Mark did not react visibly when the verdict was read. But he finally looked at me. For the first time since the crematorium parking lot. There was no anger in his eyes. There was recognition. He had miscalculated. Sentencing occurred 6 weeks later. 28 years. No early release eligibility under the statute due to financial exploitation aggravation. He was remanded immediately. No appeal bond granted. Irreversible. Outside the courthouse, reporters gathered. Microphones extended. I gave one statement. My daughter deserved protection. Silence is not weakness. Documentation is not vengeance. Truth is patient. I did not answer further questions. I did not speak his name again publicly. In the months that followed, I finalized relocation to Arizona to be closer to Emily's sister. My granddaughter's temporary guardianship transitioned into permanent custodial structure under court supervision, with family oversight and therapeutic support. I sold my minority share in the family business and structured the proceeds into the trust one had established. No access outside educational and health parameters. I never returned to the Seattle house. I did not need closure from walls. Closure had occurred in court. Sometimes people mistake age for decline. They mistake quiet for compliance. They mistake grief for paralysis. Mark mistook all 3. He believed removing me from proximity would remove scrutiny. He believed that authority within a household meant control over narrative. He believed that gradual harm would evade detection. He believed that I would collapse under sorrow. He gave me 30 days. It took 48 hours to initiate the unraveling. But the real unraveling was built long before the arrest. It was built in observation. In noting small inconsistencies. In copying files without confrontation. In testing medication without announcement. In documenting before accusation. Experience does not shout. It accumulates. My granddaughter sometimes asks about her mother. I speak carefully. I do not speak of poison. I speak of strength. I speak of vigilance. I speak of how silence can mean many things: grief, patience, preparation. And I tell her this. Never mistake restraint for weakness. The most dangerous man in the room is often the one who is listening. I am 70 years old now. I walk slower than I once did. My hair is white. But my memory remains exact. And if there is one lesson I leave behind, it is this. Dignity requires vigilance. Experience requires discipline. And silence, when chosen, is never surrender. It is strategy.